This is our third session on agency, and we're going to deal here with common agency relationships and also how to terminate an agency. So what are some of the common agency relationships that exist? Well, one that you're probably familiar with is the client and the attorney at law. So lawyers are agents of their clients. And as I mentioned to you, here in Arizona, our fiduciary duties are based basically on the same duties that attorneys have to their clients. The next one is the relationship between a client and an attorney in fact. So let's say that I was going to be out of town and I was selling my property, and when I was out of town, closing was supposed to occur. Maybe I could give my brother or a close friend a power of attorney to actually sign on my behalf. If I did, then my brother in that case would be my attorney in fact. That power of attorney that I would give him could either be specific or general in nature. So the two types of powers of attorney are specific or general. A specific power of attorney would authorize my brother in that case just to sign whatever documents were necessary in order to sell my property. I could, of course, give my brother a general power of attorney, a much broader power allowing him to conduct a number of activities for me in my absence. Now, there's also what's called a universal agency, where, and this is pretty rare, where you might give somebody the authority to do anything and everything on your behalf. And sometimes a court might order that someone be appointed as a universal agent. I guess a guardian, where someone might be fully incapacitated and the court names another person as their guardian. That guardian, in essence, becomes a universal agent on that person's behalf. Now, the one that we're focusing on, of course, is the relationship between the client and the real estate broker. Remember, agency exists at the level of the real estate brokerage company, not at the level of the real estate salesperson. So even though you personally deal with the seller, you personally deal with the buyer, that buyer might be your brother or your best friend. The agency relationship that's created is between that buyer-client or seller-client and the real estate brokerage firm that you work for. Now, as an agent, the broker's authority depends upon the type of contract they enter into. So, a broker is always a special agent when it comes to listings and buyer brokerage agreements. So what do I mean by special agent? Well, under a listing, the broker's authority is very limited. The seller agrees to pay the broker a commission, but it gives the broker the ability to market the property and to prepare and present offers. That's pretty much it. The broker can't accept offers, can't really negotiate to any great detail on behalf of the seller. Same thing with buyer brokerage agreements. The buyer authorizes the licensee, the brokerage company, to locate properties for them and to prepare and present offers for them. But again, the brokerage company cannot sign on behalf of that particular buyer. So listing agreements and buyer brokerage agreements create limited or special agencies. Whereas sometimes a broker functions as a general agent, a much broader capacity. And that typically was within the framework of property management agreements. For example, if I, as a property owner, hire you and your company to represent me to tenants, maybe I own an apartment building, what happens is you have the ability to enter into contracts on my behalf. You'll enter into leases. You may enter into maintenance contracts on my behalf with landscapers and carpenters and repair people. You're going to be collecting rent on my behalf. You'll be paying bills on my behalf. You'll be doing a lot of accounting. So that's considered to me be much broader in authority than the limited type of agency you have under a listing or a buyer brokerage agreement. So property management agreements, generally speaking, create a general agency. Now, the one thing you always want to avoid is being a secret agent. There's no such thing as secret agents in the real estate business. How about your authority as a salesperson? Well, as a salesperson, keep in mind that you always represent the broker. So if you're a salesperson, that salesperson always represents the broker, not yourself. Right? You do not directly represent the client, but you represent the broker. And you're considered to be the general agent of a broker. Now, what does that mean? Well, interestingly enough, it means what you do binds the broker. So, for example, when I first got in the business, back in the early 1970s, one of the sellers, one of my first listings, the seller said, well, you're going to advertise the property every day in the newspaper, aren't you? And I didn't know any better. I said, yeah, and he asked me to write that in the listing, and I did. When I got back to the office, the broker was livid because what had happened was I committed the broker to advertise the property every day. So we started advertising it. Fortunately for me, what happened was we did find a buyer for that property in about 2 weeks, so it wasn't too costly. But I had bound the broker to that agreement in the listing agreement. So because I, as the salesperson, was the general agent of my broker. Now, one of the questions that comes up here is a salesperson or a licensee, an independent contractor, or an employee? Well, this is going to vary depending upon the specific circumstance. Generally speaking, real estate brokers prefer to treat their salespeople as independent contractors and not as employees. Why is that? Well, because if a broker treats you as an employee, just like any other employer that you might have had on a job, it's more costly to them. They happen to have to pay into Social Security and Medicare. They have to withhold. And you as an employee would receive a W-2 stating what your income and your wages were. But there's a special carve-out that the Internal Revenue Service has made for real estate agents, too detailed to go into here. But most real estate agents are considered to be kind of in their own business, running their own business, even though they're working for a brokerage firm. So brokers are allowed to treat many of their salespeople as their licensees as what's called an independent contractor. In so doing, the brokerage firm does not have to pay into Social Security and Medicare, does not have to withhold. So if you're being treated as an independent contractor, you're going to have to make sure that you have enough money to pay your taxes. And what IRS will probably require is that you pay an estimated amount to the IRS on a quarterly basis over the years. You will also not receive a W-2, you'll receive a 1099 stating what your gross income was. So very important for you to make a determination with your broker as to how you're going to be treated as an independent contractor or an employee. Now, this is a rather complicated issue, and we're not going to go into it in any greater detail here. But if you're interested in finding out more about this, go onto the IRS's website and check it out, independent contractor versus employee. Now, finally, let's talk about how agencies are terminated. And there's 7 or 8 ways in which an agency might be terminated. Let's say you had a listing agreement and you performed your job. You brought the buyer according to the terms and the transaction moved forward and closed. That agency is terminated by performance. Another way is by mutual agreement. Let's say that you had a buyer brokerage agreement with a buyer and that buyer no longer was seeking to buy a home. Maybe their transfer fell through. They were moving to your town and they were looking for a home, but now their job transfer fell through. You and the buyer would mutually agree to terminate your relationship. Or let's say that a seller had their property up for sale and they were planning on moving, but their plans changed. You and that seller could agree to terminate that agency by mutual agreement. Third way, expiration of term. Remember, all listing agreements, all buyer brokerage agreements, all property management agreements have to have an expiration date. When that expiration date happens, comes midnight of that expiration date, that agency is terminated. Revocation. Revocation by either the principal or the agent. So let's say that the seller under a listing agreement feels that the broker or the licensee is really not doing their job. They're just sitting around, not really trying to market the property. In that circumstance, the seller could revoke the agency. Or similarly, let's say that the agent felt the seller was being unreasonable. The seller was asking the agent to do things that no agent would ever want to do. That agent can terminate that agency by revoking it. Now, in these circumstances, usually there's two sides to a story, and the seller says, well, you're not doing your job, and you say, well, I sure am. Or you say to the seller, well, you shouldn't be telling me to do that or that, and the seller says, well, why not? It's lawful. Well, the answer here is that the agency can be terminated unilaterally by either party. However, it doesn't mean that if a seller fired you after you had spent a lot of time and energy and maybe money marketing a property, that the seller might not be liable for some damages. But the point is that the agency is terminated unilaterally by the seller or the buyer, or you as the agent firing the job. Destruction of the property. Since in most instances the property has buildings on it, and those buildings are destroyed, that would typically allow the agency to be terminated. Just think about all the damage coming from natural causes, hurricanes and tornadoes and so on. Those properties are destroyed. The seller really doesn't have anything left to sell. Bankruptcy. Bankruptcy of the principal will terminate that agency relationship. So you have a listing on a property and the seller files bankruptcy. Now all of the seller's assets are thrown onto the mercy, so to speak, of the bankruptcy court. So the bankruptcy court now is the one in charge. It may be that they relist the property with you, but that might be down the road. Death or incapacity of the principal or the agent will terminate an agency. However, keep in mind that death or incapacity will not terminate a purchase agreement or a lease. One of the things I want you to think about is a listing agreement or a buyer brokerage agreement is an employment agreement. So we have a client hiring the agent. So there's a hierarchy. There's kind of a boss and an employee, so to speak. Whereas in a purchase contract or a lease, we have a buyer and a seller, or a landlord and tenant, who are on equal footings. So if a seller were to die prior to closing, the buyer could force the seller's estate to close the transaction. So death or incapacity of the principal or agent will terminate the agency, but death or incapacity of the seller, buyer, landlord, or tenant will not terminate a purchase agreement or a lease. That concludes our third section and our final section on agency.